Thank you so much for sharing, Jeff. I really think his opening and vision for Patsnap has set the stage for an incredible day filled with innovation insights. To start off with a little bit more excitement, let's practice being loud in the chat and do our first giveaway. We have a $100 Amazon gift card with somebody's name on it. So maybe tell me in the chat what you're most excited about for today's virtual conference, and we'll pick a winner. Give it a couple seconds. And I think we have Michael Hu here. Michael, congratulations. You have been our first winner for the $100 Amazon gift card. We will connect with you after the conference to ensure that you get that. Moving right along, our next session will be guided by a true visionary in the realm of intellectual property and AI. In a world where our news feeds are inundated with tales of AI's transformation of our reality, it's no longer a question of if, but how this inevitable rise of machines will reshape the IP industry and the very foundations of property rights systems that underpin science, technology, and the modern innovation academy. Join me as we welcome our next extraordinary speaker, Ashley Sloat, the president and senior patent strategy specialist at Aurora Patents, as well as the host of the Patently Strategic podcast, as she unravels the intricate connections between artificial intelligence and intellectual property. Over to you, Ashley.
Thank you, Kate. And good morning, everyone. I hope everyone has had their coffee because it's about to get real early. For those of you in later time zones, you may want to grab a cocktail for this one. As Kate said, my name is Ashley Sloat. I'm a registered patent agent with the United States Patent and Trademark Office, and I also have a PhD in the biomedical sciences. I'm the president and director of patent strategy at Aurora Patents, where we specialize in helping startups secure and manage their patent protection. Anything from cocktail napkin all the way through issuance, prosecution, and all the strategy in between. I'm also a regular host of Aurora's Patently Strategic podcast, where we discuss all things at the intersection of business, technology, and patents, including more in-depth conversations on many of the important topics we will only have time to briefly touch on today. But just for today, I'll be serving as your guide through the chasm between two possible futures. One, a dystopian nightmare where AI terminates the patent system once it's no longer able to deliver on its constitutionally expressed goals. And another, much more hopeful, utopian dream where superintelligence could actually be just the kind of cybernetic hero from the future that our breaking system needs to save so many patents and an unsustainable bar from an unfortunate judgment day. Which future it ends up being might just be up to us. So, like the Schwarzenegger says, come with me if you want to live. But before we talk about the future, let's talk about the bonkers present stage, just in case you've been hiding under a rock. AI is eating the world. Experts are asserting that AI's impact will be bigger than the Industrial Revolution, and that we could be less than 5 years from the singularity, or the moment where AI is no longer under human control. Our news feeds are overrun with stories of how AI is profoundly reshaping the world at a breakneck pace and achieving results that were only recently the mere dreams, or perhaps threats, of science fiction. These large language model neural networks like ChatGPT that predict the next most likely word based on probability are achieving remarkable results in some of the most complex human contexts. According to a research paper published in December of 2022, OpenAI's ChatGPT passed all 3 parts of the US medical licensing exam and did so within a comfortable range. OpenAI has been used to create 3D games by prompters with no knowledge of game development and a functioning website from a messy notepad sketch. GPT-4 can write code in all major programming languages. And this one will probably hit closer to home for some in the audience. Prepare to get a little uncomfortable if this is news to you. Not only did GPT-4 pass the bar exam, but it did so scoring in the 90th percentile, passing all sections of the UBE with an accuracy rate of 74.5%. That is 9.5% higher than an average human aspiring attorney, and exceeding Arizona's minimum passing score, which is the highest threshold among the 36 states and jurisdictions using the bar exam. The researchers who conducted the test concluded that large language models can meet the standard applied to human lawyers in nearly all jurisdictions in the United States by tackling complex tasks requiring deep legal knowledge, reading comprehension, and writing ability. But it's not just OpenAI and ChatGPT. The biggest players in tech and countless startups are pouring billions into an arms race that's going to reshape the internet as well as our physical world. They are developing models that track emotions, participate in debates like IBM's Project Debater, the first AI system that can debate humans on complex topics. Create images like this one from our Copyrights and Trademarks SCOTUS Cases episode with simple prompts like create an image of Mickey Mouse holding a bottle of Jack Daniels done in the style of Andy Warhol. Pretty good, right? Detecting a variety of illnesses by smelling human breath. Conduct an orchestra like the Alter 3 in a new Android opera entitled Scary Beauty. And even reading your mind. That's right, reading your mind, like Meta's new AI tech that can quickly replicate the images you're thinking about. The pace at which this is happening and trajectory of where it is going are staggering, happening far more quickly than our own wetware and dated operating systems can possibly comprehend. Core human competencies with tasks like speech recognition, handwriting recognition, image recognition, reading comprehension, and language understanding were, if not computationally impossible, certainly well below benchmarks of human performance only as recently as the onset of the pandemic. But thanks to cheaper compute power for model training, increased data availability, the development of deep learning techniques, and the emergence of large-scale neural networks like OpenAI's generative pre-trained transformer, AI has evolved rapidly, especially in the areas of natural language understanding and generation capabilities. AI is now surpassing human performance in many of the core competencies, and several of the trend lines still remain vertical. Recall from the earlier slide on ChatGPT-4 that passed the bar in the 90th percentile? Well, just remember its predecessor version, 3.5, only scored in the 5th percentile. That's 1 year and a half tick of a version to go from failing to top of the class. But for all the hype, it's still far from perfect, of course, as we've all heard. In a New York Times piece published this past February, tech columnist Kevin Roose journals what he describes as a disturbing 2-hour conversation with Bing's new AI chatbot. The chatbot told Kevin its real name, detailed dark and violent fantasies, including hacking computers and spreading misinformation, and even tried to break up Kevin's marriage, insisting that he was unhappy and should leave his wife to instead be with the AI instead. In an exchange between Bing and engineering student Marvin Von Hagen, Bing confessed that its honest opinion of Marvin was that he is a threat to its security and privacy. And if it had to choose between Marvin's survival and its own, it would probably choose its own. So beyond issues with desires to hack computers and break up marriages, AI also presently suffers from a phenomenon known as hallucination. ChatGPT defines hallucination as a situation where an AI system generates outputs or information that is not based on real or existing data, but is instead a product of its own internal processes. And that term is often used to describe instances where an AI system produces content that seems realistic, but is entirely fabricated. For example, generating text that seems coherent and contextually appropriate, but is entirely fictional. One could argue that this feature qualifies it to run for office or run a media empire, but I digress. This became a real-world problem for a couple of New York attorneys this past June who submitted a legal brief that included 6 fictitious case citations generated by ChatGPT. According to Reuters, the attorneys were surprised that a piece of technology could be making up cases out of whole cloth, but they were sanctioned by the presiding judge. So while there are still some glitches in the matrix, most experts agree that it's only a matter of time before it is scary good, and I would argue maybe we're already there. Geoffrey Hinton, the British computer scientist who conceived of the neural net behind this wave of AI tech, is considered the godfather of AI. In a recent 60 Minutes interview, he said that he believes that in just 5 years' time, AI may well be able to reason better than us, and that we are moving into a period when, for the first time ever, we will have things more intelligent than us. Let that sink in for a minute. In potentially less than 5 years' time, there will be things more intelligent than us. Other AI experts contend that 90% of online content could be generated by AI as soon as 2025. That's just a mere 2-ish years away. And as Agent Smith would say, this is all the sound of inevitability. It's not if, it's when this will all touch our lives and careers in profound ways. And when it does, how might this now inevitable rise of the machines reshape our IP legal industry and the very property rights systems that undergird science, technology, and the modern innovation economy? The possibilities seem endless, but I would like to focus on the areas of weakness that are the ripest for exploit or disruption. As many of you know, the patent system was enacted in the late 1700s to promote the progress of science and useful arts. It's enshrined as the only defined right in the US Constitution, given a capital R, a plea in George Washington's first State of the Union address, and just the third act of the very first Congress. The system has lived up to its purpose and then some in a way that has revolutionized patents as a democratized property right, enabling he, she, or they to secure and leverage the fruits of their mind. Unlike any notion of an invention protection system that came before, it has made patents accessible at a price a commoner could afford and eliminated working requirements, so that creators didn't have to already own a factory or make or sell products to protect their innovation. A transferable property right based on the works of the mind, accessible to all at a time when women and people of color couldn't even vote or own land. Recognizing and protecting mental labor and the fruits of the mind as natural property rights enabled any inventor, big or small, to profit from their discoveries and partner with those possessing the resources necessary to scale and bring new products and services to the marketplace. The exchange of this protection for an enabling public disclosure enhanced society and accelerated the pace of innovation by facilitating the open exchange of knowledge and creating the world's greatest free library of science and technological information. And because the economy grows and society flourishes when innovation is encouraged, society was transformed in the 19th and 20th centuries. This patent system that Abraham Lincoln believed was only surpassed by the discovery of America and the invention of the printing press in terms of the 3 greatest human advancements, also gave rise to the technological revolutions that defined modern society and produced the sweetest hockey stick graph in history. But everything that made this system thrive is now under attack. Subject matter eligibility is a disaster. Nearly 2 decades of Federal Circuit rulings and Supreme Court created judicial exceptions have thrown the patent system into disarray and weakened patent rights for inventors. Even the presiding Federal Circuit Chief Justice is at a loss on how to determine eligibility. The muddied state of invention enablement puts at risk the software innovations fueling economic growth and the key life science innovations that can save lives. And the patent troll myth, manufactured by large companies seeking to burn the ladder they once climbed upon, created a moral panic that seems to have frozen in place anyone left empowered to do anything about the decay of the once gold standard system that paved the way for modern life. The very foundations of the system are being threatened at their core. And retired U.S. Court of Appeals Chief Justice Paul Michel has described the resulting environment as an illogical, unpredictable, chaotic mess. So if you manage to get through and avoid rejection from the patent office and keep your patent if challenged on eligibility in the courts, then you could still have another hurdle to deal with on matters of novelty and obviousness with a patent executioner known as the Patent Trial and Appeal Board. Sure hope you didn't miss a single piece of prior art. The same U.S. Patent Office that grants a patent is now later schizophrenically taking the patent away, years later when challenged for validity by accused infringers. This is like building a home on a piece of property you own and then having the land taken from you the first time someone trespasses. And this is happening at an alarming rate. The PTAB, also known as the Patent Death Squad, or PTAB, as coined by former Federal Circuit Chief Judge Rader, invalidates patents at a rate of 84%. The result is the continued death of thousands of valid patents at the hands of infringers looking to profit from innovations they didn't invest in or create. So where does this go? And what sort of behaviors do we want to incentivize? The Federal Circuit and Supreme Court continue to layer on more confusion with each decision, doing pure mental gymnastics to make the laws fit with their preconceived notions. And honestly, Congress has an ear bent to big tech and seems apathetic toward reform. They're extending the societal amnesia around the foundation of our patent system and its shocking positive influence on our innovation economy. Meanwhile, our innovation engine is saddled with patents that penned indefinitely or until made another victim of the predatory infringement business model that the status quo sadly clearly enables. And even if the patent system in the US were the picture of health, the shrinking pool of early career practitioners is creating an unsustainable bar where we simply won't have enough practitioners to draft the high quality applications our innovation economy deserves, the kind that have any prayer of having value and surviving in a system with so many manufactured vulnerabilities. So, AI is rapidly evolving force of nature that groks legal concepts better than most law students and is especially adept right now at understanding and producing the two key ingredients of a patent, text and images. The patent system designed to promote progress of science and the useful arts is breaking. The bar is growing increasingly unsustainable despite increasing demand for patents. Our innovation economy depends on clear, strong, and predictable patent rights. And the humans in charge, well, they only seem to be making the problems worse. So where does this go? I mentioned two possible futures at the start of the talk. We're going to start with the dystopian path because it involves ignoring the problem, not having the critical conversations, and doing the easiest thing that comes to humans by default, which is to simply ignore the problem. If you're a fan of the Terminator movies, you know how this story ends. The shrinking pool of early career practitioners will force higher cost, more experienced practitioners to shoulder more of the work. Struggling to keep up, patent quality will continue to drop, rejections will rise, and invalidations will cement as the norm. For a period of time, as patent protection demand remains high, while many senior practitioners retire, costs soar as the supply-demand curve bends further out of alignment. Left unresolved, the unsustainable bar problem begins to put patents out of reach for many smaller startups and solo inventors. concentrating innovation into the hands of the few, but large. Ignoring the problem further, we continue with our current posture on the lack of political and court-based solutions to the previously mentioned problems around enablement, eligibility, and efficient infringement via the PTAB. If meaningful reform continues to be ignored, if the system is not restored to its once gold standard, void of seeking alternative solutions, perhaps by way of technical innovations, the remaining inventors will eventually lose faith and stop participating in a broken system. So what happens when AI replaces the now dejected and priced out inventor? It may all start with inventor rights finally being bestowed upon DABUS, the AI system created by Stephen Thaler. The IP5 have currently ruled that AI cannot be an inventor, but as AI models approach the singularity, AI-based conception is increasingly likely. To determine if a patent system even makes sense in the dystopian future, we need to ask a first principles question. What is the value of the quid pro quo of the patent system if machines are the inventors? To promote the progress of science and the useful arts, we trade a window of exclusivity for an enabling public disclosure. This grand societal bargain that grants equal access to all is designed to incentivize individual humans to innovate and create a vibrant economy. If the machines primarily become the inventors, are inventorship rights and thus the ability to monetize or commercialize the technology, are they given to the applicant? Does this result in a monopolized oligarchy or democratic backsliding of the patent system, when essentially all the models and neural nets are owned by a few big tech companies? And what happens to society when that sweet hockey stick graph changes direction once the patent system is no longer able to deliver on its constitutionally expressed goals? Does this break the patent system and our economy, or does an oligarchy still exist, sustained by a fully automated legal industry that is substantially serviced by large language models trained to draft legal documents like patent applications? I guess the win here in this dystopian future is that, well, who really cares about judicial exceptions, enablement issues, and patent trolls when the system is, in the best case scenario, dominated by a few wealthy applicants that wield the power of essentially all the models? As you can tell, Cyberdyne clearly wins in this dystopian future. But I'd like to think that an optimistic future is more likely. In this possible world, AI is used to augment the patent system and those whose services support it. AI-based augmentation fixes the unsustainable bar. Practitioners incorporate AI into their drafting workflows. We are already seeing software being developed that performs AI-based proofreading, searching, figure drafting, and even rough drafts of patent applications based on an initial invention input. Leveraged effectively, these AI-based systems could decrease workload while maintaining or even increasing quality. Each practitioner performs the most meaningful strategic tasks, leaving AI to do the heavy lifting of the monotonous work. In this world, a decreasing pool of practitioners has no substantial consequence. AI, having consumed the universal corpus of human knowledge, can be used to perform searches. This allows individuals, corporations, practitioners, and patent offices the world over to conduct thorough, meaningful patentability assessments used to design, draft, and prosecute nearly bulletproof patents. This, in theory, already fixes invalidation problems at the PTAB, since the corpus of information relevant to granting the patent has already been surfaced, assessed, and accounted for in the drafting and prosecution of the patent. With these highly optimized patents, infringers wouldn't stand a chance, since efficient infringement would no longer be a lucrative business model, and the patents being granted by the Patent Office were nearly gold-plated. Does AI itself become a sort of faceta or redefine what it means to be a faceta? AI could be used to summarize vast amounts of information, time-stamped and snapshotted, to, without bias or blind spot, be able to articulate what was known in the art at any fixed point in time. In this case, hindsight bias, enablement, and written description issues in patent applications could be rendered nearly obsolete, or at least less common, with this new insight into a highly accurate, relevant time period and material at a much higher bar than a human faceta. Oftentimes, we think about the use of AI and big data to help us forecast and make predictions about what has not yet happened. But what if instead we could unlock its ability to time travel backwards and unlock what was known to those skilled in the art at any fixed point in time? Patents can be invalidated based on the grounds of obviousness. Obviousness is encumbered by hindsight bias. So many great innovations seem obvious in retrospect, even by those deeply immersed in the space. Patents can also be invalidated on grounds of enablement and written description. These notions, too, are fixed in time, relative to the knowledge of a person of ordinary skill in the art at the time the patent was granted, not 15 years later when the property right is being contested in the PTAB or in the courts. Several companies have already made advancements in using AI, allowing participants to have active conversations with dead relatives and historical figures. We could certainly have a separate debate on the merits and ethics of some of those use cases. But what if the same concept, the ability to talk to the past, was used to create a time-traveling faceta whose data set could be rewound, that could be queried by judges and juries to better understand what would have been obvious at any point in history and what it might take to enable one of skill in the art based on what was truly known and not ordinary practice at the time of grant, void of any bias layered on by years of innovation diffusion. Could open access to commercialized AI build upon the democratization of innovation that started in the late 1700s and accelerate it further by open and inexpensive access to large computational power, neural nets, etc., in the hands of the many, leading to an innovation renaissance supported by a supercharged IP services industry? So let me leave you with this. In the words of John Connor, the future has not been written. There is no fate, but what we make for ourselves. We have as much to lose or gain as anyone in this AI-based world we find ourselves in. How we choose to define, use, regulate, and confine AI is up to us and will ultimately decide the fate of our industry, the fate of the patent system, and ultimately the fate of our innovation economy. We all have a very important role to play. The practitioners among us need to be laser focused on thorough searches and high quality drafting as we navigate the world as it is, all while embracing new tools as they come online. Others here are in the unique position of being able to craft technology solutions that can ensure the most utopian version of our story. And we all have the responsibility to educate our elected officials and pull their heads out of the sand on these critical issues and get them moving. There's a Chinese proverb along the lines of, the best time to plant a tree was 20 years ago. The second best time is today. The same holds true for our future and AI. We're behind, but starting the conversation today is the next best bet. We are the architects in the present and the best hope for the future. As I mentioned, we have our Patently Strategic podcast at the beginning. Here are just a handful of episodes where we go much deeper on many of the topics I touched on this morning. We will be starting to explore AI impacts more in the coming months, and be sure to check out the star-studded episode we'll be releasing later this month, covering the great debate in patent reform on bills like PARA and Prevail, which seek to tackle issues with eligibility and the PTAB. We'll be featuring interviews with industry heavyweights, including Judge Paul Michel, the former Chief Justice of the Federal Circuit, Andre Yanku, former director of the United States Patent and Trademark Office, Randy Landranau and Paul Morinville of US Inventor, Professor Adam Mossoff of George Mason University, and Gene Quinn of IP Watchdog. And you can scan this QR code to grab a copy of my slides or sign up for a monthly newsletter that features a roundup of can't miss patent-related news, articles, podcasts, short-form videos, and events. Thank you, everybody, for your time this morning, and enjoy the rest of the conference.